Welcome once again to Lehto as well. I'm Steve Lehto. As you can tell from the wonderful acoustics in the room and the fact that someone's sitting next to me, I am obviously not on my set. I'm in someone else's set, and this set would be the office of Adam Taub. How are you, sir?
I'm good. How are you?
Good to see you again. And Adam, I've known Adam for, I'm guessing, 25 or 26 years. How long have you been practicing law?
I've been practicing law since 1993, and I've probably known you since 95. So what is that? We're not accountants.
Yeah, and I would say roughly 24 years, but again, I'm not doing math here either.
Right.
So, but I actually know where I met you, believe it or not, at a consumer law section council meeting with the State Bar of Michigan in Grand Rapids. I remember standing in a parking lot outside of my Jeep Wrangler talking to you about that. So that's why I know I can actually place that odd moment in my memory. I do primarily lemon law. It's almost all I do. But in the old days, I used to handle all kinds of wacky stuff. And I gradually got away from the wacky stuff and just decided to focus on cars because I like cars. Mm-hmm. Now, I know that you do a lot of car stuff, but you've also drifted off into some of the wacky stuff. And by wacky stuff, I just really mean the consumer issues that I don't get involved in. And so one of the things I was talking to you about recently is, for instance, you handle a lot of cases in your practice where someone comes and sues somebody over a credit card debt or a auto loan. Can you explain to me a little bit what's the most common thing? What's the prototypical thing you see?
Well, mostly what we see is somebody calls us up and they've been served with papers.
Okay.
And they want to know what to do. And the best, shortest answer is get a lawyer.
Okay, and now I can tell you, and I'm an attorney, so I've sued people before, and you have as well.
Right.
The summons and complaint that you get when you're served, when you're sued, they hand you a piece of paper and it says, 1, you are being sued. Okay.
Ideally, it says you are being sued.
Number 2, you have 21 days if served personally, 28 by mail, to answer the complaint or default matter against you. And it goes 3, we highly recommend you get an attorney. And then it says, I've seen it before, and it says, if you need help, here's some numbers to call. But a lot of people go, why do I need an attorney? Do they need an attorney?
Yeah, they need an attorney,
Okay.
Steve. Even if you're being sued for a small amount,
right?
If you go into court without an attorney, you're going to lose.
Okay.
You're going to get buried. This is a forum in which attorneys practice and make money. They've been doing it for years. The attorneys on the other side know the system. And what they're trying to do is trying ultimately to get a judgment against the consumer.
Right.
And what a judgment means is basically you lose. The court ordered that you owe the money, and you owe the particular amount, and then within 21 days of that judgment entering, they can take your bank account, garnish your wages, put a lien on your state taxes, put a lien on your property. So it's a pretty serious thing that you really don't want to mess around with. You do need a lawyer.
Well, let me back up, though. So let's suppose, and I'm just, again, throw a hypothetical at you. Let's suppose I get sued over a debt, and I go, I actually do owe the money. Shouldn't I just go into court and go, yeah, I owe the money? What's an attorney going to do for me if I actually owe the money?
Well, let me just say this. Whether or not you owe the money, whether or not you think you owe the money, whether or not you think you owe that amount or maybe a lesser amount, there are defenses available to you that should be filed in court, and those defenses are going to help you maybe get the case dismissed.
Okay.
Maybe pay a lesser amount, and in some cases actually an investigation, a review of the attempts to collect the debt can lead, in some cases,
right,
to you not only defending yourself against the lawsuit, but also filing a lawsuit against the debt collectors.
Well, let's back up a split second. The most common defense I'm going to think of because it's a pretty good one, is if there's a statute of limitations issue. In other words, a debt collector is chasing you for a debt that's really old, and they've sued you for it anyways. You got a lawsuit, and you go, I think this debt's like 8, 9, 10 years old. And so, number one, if I don't defend that, that'd be bad because they can still get a default judgment on it, right?
It would be bad to not defend that statute of limitations or not raise that statute of limitations defense. And if you don't do it at the right time, you waive it.
Okay. And so how often do you see someone being sued over old debt? And talking about debt that's so old that it's uncollectible legally if somebody raises the right defenses?
It's not rare. It's not rare. It's not common, but it's not rare. And that's where an attorney comes in, a consumer advocate who can look at all of those, the statute of limitations defense, whether or not there are false charges on in the lawsuit or in your credit card account or even in an auto lending situation. Somebody needs to scrutinize that whole lawsuit, the contract that's attached for any possible defense. So in the example that you give, if there's a statute of limitations defense, like I said, it needs to be brought up at the right time. You need to know what you need to prove and what is the responsibility of the other side to prove. Or else you're just going to lose that defense. And you're also going to lose the potential to go after the debt collector for suing you for a debt that is unenforceable.
Let me ask you a question. I know that you do a lot of this, and you know, people talking about lemon law, I can give like very general things about like what kinds of things I see. How often do you see lawsuits filed by somebody other than the original person who lent the money? In other words, the debt's been sold or assigned or given away. Someone else is now pursuing it, even though they're not the person who lent the money.
More often than not. More often than not in the credit card arena and sometimes in the auto lending arena, what you're going to see is you're going to see debt buyers that step into the shoes of the original creditor. And there's a lot of stuff floating around on the internet about some cockamamie theories that you don't have to pay people who are debt buyers. I would not rely on that information. Again, I'm going to tell you that it's not going to work in court.
Well, I know that the idea that you can assign or sell debts, that's been a long-standing concept in Western culture for hundreds of years. If I lend you money and have a contract that says I can then assign that contract to somebody else and you have to pay them back, that's a common thing. But the question is...
Yeah, not only is that a common thing, that's the buying and selling of debt, the insuring of debt, the... compiling debt and selling it on the stock market, that's kind of the basis of the global economy, Steve.
It is.
But that's for another day.
But what I'm saying, though, is many people don't understand how that applies to them. So in other words, I take a credit card, I buy a bunch of stuff with the credit card, I don't pay the bill, and 5 years later, there's some company I never heard of saying, you owe us money. And some people get confused. They go, how is that possible? And it's this exact same concept that if you buy a car and you finance it through the dealership, they immediately sign the paper to the lender, like Ford Motor Credit or something, and you're paying them. It's the same concept, but just a little bit more removed, and people don't realize it. It touches every aspect of the lending, credit, debt world.
Right. The buying and selling of debt is something that is just a fact of our economy, and it's negotiated. The lenders don't pay as much for that debt as the face value of the debt. They pay a reduced amount based on a whole bunch of factors, and it's all negotiable. But one thing to remember is when you're being sued, the amount that you're being sued in a lot of cases, in most cases, is also negotiable.
Well, I was going to say, so if a debt buyer buys a bunch of debt, and we know they're not paying $1 on the dollar for it,
They're not.
So the interesting thing is each time the debt changes hands, I'm assuming two things happen. One of them is, doesn't it make it a little harder for them to prove the debt? In other words, if you have someone comes to you and says, look, I'm being sued by somebody who's now holding this debt, and it looks like the debt's been changed hands a bunch of times, doesn't that help you defend the case?
It helps a lawyer defend the case.
Right.
Okay.
Right.
Let me just tell you this. First of all, when you get sued by a debt collector, a debt collection law firm, that whole process, whether it's a debt buyer, whether it's the original creditor, whether it's for $100,000 or $1,000, that whole process is automated.
Right.
Okay. So when you don't have somebody advocating for you in court, and you don't know the rules of civil procedure, and you don't know who the judge is, and you don't know how the judge is going to rule based on your experience in court, that process is basically going to roll over you like a steamroller.
Right.
Okay. So to answer your question, yes, it's harder for the other side to prove that there's a chain of title, to prove those assignments, to prove that they're actually the real owner of the debt. And to add to that, what rights did they buy and what rights did they not buy from previous people in the chain of title, so to speak.
Right.
So you need to get an attorney to look at that and make the case more difficult for the other side to prove, or maybe I can put it another way, make the other side meet their burden of proof.
Right.
And the other side, sometimes they can't, and sometimes they make a business decision that it's too expensive. But having said all that, I can't stress enough my original point, which is get an attorney to represent you. Just like if you were charged with a crime, whether you committed the crime, whether you didn't commit the crime, you would want an attorney there representing you to protect your liberty. In this case, you're hiring an attorney to protect your wealth and your property.
And one other aspect, though, is if somebody bought the debt for less than $1 on the dollar, that means they don't have, like, let's suppose I'm suing somebody's being sued for $10,000, okay?
Right.
The person suing them does not have $10,000 in that game. They got less than that because they bought the debt for less than that.
That's correct.
So I'm assuming that I come to you and I say, hey, Adam, I'm being sued for $10,000. I actually owe the money. I took out a $10,000 loan to buy my jet boat, 8 years ago, and you're going, okay, what kind of defenses might I have here? Let's assume, though, that the statute of limitations is somehow, the statute's still good, everything's good. But the question is, are you going to be able to possibly negotiate the debt down even though I owe the money?
In 99% of the cases, yes.
Okay.
In 99% of the cases.
We like to think we're in the 99%.
Yeah, we are. In 99% of the cases, the answer is yes. You've got to remember that it costs the other side money and resources and time to litigate these issues.
Right.
They have to show up with witnesses. And again, if you're just representing yourself, you're not even going to get to the witness part. You're just going to get steamrolled. You're going to lose before you even know it.
Right.
But if you have an attorney who can slow down the steamroller, slow down the snowball going down the mountain, and make the other side prove its case, then we start to negotiate.
Okay.
And then we start talking about what a good result is for you as the consumer, while the other side's lawyers are talking about what is a good result for them.
Right.
There's always the possibility that even if they get a judgment, they're not going to collect anything.
Right.
There's always the possibility that they might lose.
Right.
There's always a possibility that it's going to cost them more to litigate the case
right.
than come up with a good faith settlement.
And even collection can cost money. In other words, they get a judgment against you. They still have to jump through hoops to get the money out of you if they're going to try to garnish your wages or get someone to come out and seize your assets and auction them or something. And so there's going to be transactional costs in that aspect of it as well.
Yeah, they need to factor all of those things in, and that's what they're doing while we're talking about on our side whether or not we can get the case dismissed. If we can't get the case dismissed, what can you afford to pay that's not going to kill you? Terms like interest-free payments on reduced amounts and all sorts of things are available. But if you lose the chess match in 4 moves, you're gonna have a problem, and you're gonna have a court order that says you owe them the money.
Right.
The cost of appealing that is it's cost prohibitive.
Right.
So you want to start right at the ground floor. You want to call an attorney right when you get served with a lawsuit. And I want to talk about what I see in court. I go to court all the time on these things, and I see people trying to represent themselves.
Right.
And I'll tell you, the number one thing that I hear judges say to pro se litigants who are trying to defend themselves against credit card companies and debt collection lawyers. You know what the number one thing I hear?
I can actually guess.
What?
You need to hire an attorney. Or you should hire an attorney. You'd be better served if you hired an attorney.
That's actually the number. That's the second most common thing.
Okay.
The number one thing I hear the courts say, I hear the judges say is, "I'm sorry. I'm sorry. I don't have a choice here. You missed a deadline. You didn't file a proper answer. You did not respond in writing to this motion, and I understand, sir or madam, that you're telling me that you don't owe this debt, or that it's 20 years old, or that you never even had a Home Depot credit card.
Right.
But I'm sorry, the time to discuss that is over. And that occurs before there's any trial. This is not like Judge Judy.
Right.
You don't just go in and say it's not mine. All of the rules of civil procedure require that things be done on certain time limits.
Yep.
If you miss a deadline, you lose.
Yeah, and I've seen judges, and I don't do as much in this field, but I've been in court enough where I've seen judges give the lecture before, where they've said things like, you're allowed to be in here by yourself. You don't have to have an attorney, but we're not going to suspend the rules for you. We're not going to change the laws for you. The court rules are the court rules. The court operates the way the court operates, and if you choose to be in here without an attorney, good for you, but you're going to be held to the same, maybe not the same exact same standards, but the rules are the same. If you don't know the rules of the game, you're going to lose. That's pretty straightforward.
Right. And like I said, the system is automated. The other side, the debt collection attorneys, are trying to get to point A, which is suing you and serving you with a lawsuit, to point B. And point B is getting a judgment, a court order that says you owe the money, and that's it. And once they get that, 21 days and they can start collecting it. So it's imperative to get an attorney now, especially in Michigan, where the standards for setting aside a default judgment are very high.
Right.
Michigan does not look kindly upon people who don't answer complaints on time, who don't answer motions on time, and that's just the way it is. So I talked about seeing people in court getting buried by the other side. One of the calls that I get from people is the call where they've come out of court and they don't know what happened.
Right.
They went in. They thought it was some sort of trial or some sort of Judge Judy or thing, and they tried to make their case orally, and they walked out with a judgment against them.
Right.
And they're calling me to try to deal with that. And in those cases, not a lot I can do.
Right. So one of the things that people also don't understand is that, there's a period of time within which they have to sue you within the statute of limitations.
Right.
So that the case doesn't become stale. But once they turn it into a judgment, it starts a new clock running. In other words, if there's a 6-year statute and you get sued at 5 years and 11 months, it's not like if they get a judgment there, they only have 1 month to collect it. A judgment is good for?
Well, for 10 years.
At a minimum.
Unless.
Right.
You file what's called an ex parte motion to renew the judgment. And that's another 10 years.
Another 10 years. So they can wait till the very, very end of the statute of limitations, and if they get a judgment against you, then they can chase you theoretically for 20 years on that judgment.
Right.
And as anybody will tell you, you'd rather defend the case than to defend the judgment.
Right. You would definitely rather defend the case and try to get it dismissed, if that's at all possible.
Right.
Try to work out a favorable settlement, if that's at all possible. But you definitely have a ton more options right at the beginning. So
right.
You get sued, call a lawyer right away. Don't wait. By the way, here's an interesting thing. There's a date on your summons in the state of Michigan.
Mm-hmm.
And a lot of people think that date, it is the time for your court date.
Right.
Or when you have to answer it. There's a date, it's usually 90 to 120 days in the future. That's not a date to appear. That's a date when the summons expires.
And
Ignore that.
Yeah, as long as they've served you within that, they got good service on you.
That's right. Once you get that lawsuit in one way or another, either by mail, if they hand it to you, if they drop it at your feet, if you have knowledge that you're being sued, you need to get representation.
And I'll tell you my favorite horror story about this. I had a client once, and he was a client of mine in another case, and he called me up one day and he goes, "Hey, Steve, I'm being sued. Can you take a look at the lawsuit?" So I foolishly said yes, and he walked into my office at noon.
Oh, great, yeah.
It was day 21.
Yeah.
I had to draft the answer and run it to the courthouse myself to get the answer filed on time.
Right, one of those courthouses that closes at 4:15.
Yes. So
right.
People don't understand. Even lawyers, we view deadlines like they're drop dead dates. You've got to get something done here. You've got to get it done here. And
right.
Non-attorneys don't understand how imperative this is that you hit these dates on time.
Right.
So the question people are going to ask right now is, Steve, it's great that you're talking about this, and Adam's great for contributing the information, but really is it worth me hiring an attorney to defend against a debt, especially if I owe the money? In other words, how do I figure this out? In other words, I'm being sued for $1,000, or being sued for $5,000 or $10,000. What's the amount, or how would I know that?
Well, a lot of that, it's going to depend whether it's worth it. First of all, I'm not going to twist anybody's arm to hire an attorney. I've got a lot of cases. I've got a lot of stuff to do. But again, you need to get an attorney. Whether it's worth it to you, do you want? You're being sued for $1,500. Do you want to find $1,500 missing from your bank account? Do you want to find $1,500 garnished from your pay?
Right.
Is it worth it to you to avoid having a judgment on the record against you, as opposed to a something that doesn't necessarily hit your credit reports? So the question is what does your situation look like? I do have people who come to me, they're being sued for a relatively small amount of money, maybe $1,000, $1,500. They've got 10 judgments against them. They don't have any income that's really garnishable, or they have very little income. If it's totally hopeless and you have a large amount of debt, there's other attorneys that can handle your situation, maybe a bankruptcy attorney.
Right.
But if you're at all collectible, if you have a job, if you're looking in the next 10 years to buy a house or want to pay less on insurance and car rates, you want to avoid having a judgment taken against you, and ultimately try to get into a situation where you can pay a smaller amount, a drastically smaller amount, sometimes in very small payments over a long period of time.
Right.
And make it affordable. I had a client who had about $100,000 in, I think there were 7 separate cases. They were private loans, and he only made a certain amount of money. And after a lot of litigation and a lot of negotiation, that guy who's gainfully employed, I mean, he wasn't when he went into default on loans, but he's
right.
now gainfully employed. He's got a family. He's got a house. That guy's paying a payment which is about 1/4 of what he would have had to pay,
okay,
and with no interest,
right,
on roughly 45 cents on the dollar.
Wow.
And as long as he stays current, everybody's happy.
Okay.
And it's going to take a while, but that guy's going to get these loans paid off, and he's going to have the whole situation behind him. I know I'm not supposed to get this table, but at a much more affordable rate
right.
than what he would have had to pay if he had gotten judgments against him.
And one of the things that I glossed over this earlier, but I mentioned that if they get a judgment against you, it's good for 10 years, and it get renewed for another 10, so they can chase you for 20 years. And I have people who flippantly comment to me to say, that's okay, I'm not collectible. And they don't understand that short of an absolute discharge in bankruptcy or something like that,
right,
that someone might get a judgment against you and sit on it for 9 years. Right. And then pull it out in 9 years and see what you're doing then. And you might be uncollectible today. You might be. Most people aren't. They think they are, but they're not. Okay.
That's right.
And I've had people who proudly say, "I'm not collectible." And I'm like, you need to raise your standards a little bit if that's how you're, what you're proud of. But the point is that 9 years from now you might be collectible. I mean, who knows? And so the point is, you shouldn't. It's sad that we have to advise people. But do you really want to live your life to where my goal is to never be collectible? At least for the next 20 years.
No, you don't. You don't want to live like that. You don't know what's going to happen, and having these things hang over your head is very stressful. Let me give you an example of a situation where my client, who I represented down the road, and it was quite difficult. But this client bought a vehicle. Financed through a subprime lender. I'm sure you can guess who, and this was and paid $10,000 cash price for the vehicle. Okay. The vehicle probably at the time was worth, I'm going to guess, 1,000 scrap value on a sunny day.
Okay.
All right. Vehicle broke down. Client couldn't get to work. Couldn't pay for the vehicle. The vehicle was repossessed. And the client was sued, and this guy ignored the lawsuit and ended up having a judgment taken against him for about $20,000. Worked under the radar for a while, and the judgment was renewed as soon as the guy got a decent job. Mm-hmm. With insurance and a pension and all, they started coming after him.
Yeah.
And the client said, but that car never even ran.
The time to defend it was back then,
right.
Not now.
And all of those issues about the car, about the condition of the vehicle,
price,
the warranties, the price, all of those were things that could have been raised in the lawsuit if he had just gotten an attorney back then. We can go in those types of lawsuits where the auto lenders sue people for these exorbitant loans. we can bring the dealer into those lawsuits.
Right.
All of that is available at the time, but it's not available 15 years later.
Right.
Now, fortunately, he got a really good attorney, and there was some negotiation that went on, but we could have done a lot better for the guy, lot better for the guy, saved him years of stress if he had just said, I'm being sued, this is pretty scary,
Right.
but I need to get an attorney.
Yeah, and the other thing that people don't understand, let's take my hypothetical uncollectible guy. The guy's uncollectible, and he's going to keep it that way for as long as he can live, okay? If he ever gets a job,
Right.
someone's going to come knock on the door one day and drop a thing on the employer and say, I need to see his wages because I might want to garnish his wages.
That's
now,
right.
Now, the boss might go, oh, here, I'll fill this form out and I'll work with this guy, and then let you know, by the way, there's some guy here who wants some of your wages. There are some employers out there who don't like going through that paperwork. And I've heard of people who've said, I went and applied for a job, I was working, and next thing I know, I got fired because somebody came by knocking around, saying I owed them money. And so it's not just the simple matter of, I have a judgment, you're going to pay me money or not. It's, I have a judgment, and you're going to pay me money, or I'm going to chase you to the ends of the earth. And other people might find out, and not all debt collectors, and you can correct me if I'm wrong, but not all debt collectors are ethical. And so sometimes there might even be collateral damage in terms of who else finds out about this, who hears about it, and your life might not just simply be a matter of me saying, you want money? No. It gets more complicated than that.
Right. It makes life very complicated. You can try to make yourself uncollectible. I've had people say, I'm uncollectible, both my cars are, I just started leasing both my cars. I just purchased both my cars. They're underwater. I've had very diligent court officers repossess leaned up cars.
Oh, God.
Is the court officer going to get anything from selling that car? No. The court officer is going to get paid.
Right.
For repossessing that car.
Yeah.
Is the judgment creditor going to get anything? No, but you're going to not have a car.
Right.
You're going to have now you're going to have a judgment and a repo on your credit report.
Right.
And that can be over $1,000 debt.
Yeah.
So I wanted to talk about affordability, though.
Well, I was going to ask you, and I was going to end with this, perhaps.
Okay.
And that is this. I tell people, especially in my videos, that if they have questions, they can call me and talk to me, or I'll hook them up with somebody who can talk to them about whatever their issues are. And in the old days, I'm talking about 30 years ago or more, the idea of calling an attorney meant you made an appointment, you go in, you pay them some money, you get an opinion, you leave. Because of the plethora of attorneys in North America, there are herds of them. It turns out that you can actually talk to many attorneys for free. Do you talk to people for free?
Yeah, we do routine free phone consultations. We don't take any money if I don't think that I can be of service in some way defending these lawsuits.
So someone can call you up and say, hey, look, I just got sued. I got these summons and complaint. Hopefully it's fresh. And I want to talk to somebody about this. You're going to be able to ask them pretty quickly, when did you get served? What court is it in? How much do they want from you? Does the complaint list an exact dollar value?
What you just said is our screening process. First,
Okay.
When were you served?
Right.
What court is it in? How much are you being sued for?
And
who's the creditor?
And most of these complaints are going to have attached some kind of contract or something. So it shouldn't be a surprise. In other words, they don't say, gee, I don't know what they want. The complaint's going to say, here's who, or do they get confusing?
Well, okay, let me tell you this. To a layperson, they get confusing. To a layperson.
Okay.
Sometimes to somebody who does this all the time, they're also confusing because some of the time they're so poorly written.
Okay.
There's typos.
But let me guess. Once in a while, someone will call you and be describing something, and you'll have an inkling and go, can I ask who the attorney is who filed it? And you recognize the law firm, correct?
Right. Absolutely. I do recognize all the debt collection law
big
firms
ones,
that are local.
Yeah.
And probably if you started reading me the first 3 or 4 paragraphs, I would know who drafted the lawsuit.
Which does help, because then you'll have a familiarity with working with these attorneys previously. You know what they might be looking for with that particular client, how much you might be able to get on a discount, what kind of defenses you may have to raise, things like that.
That's right. And, you know, as far as, you know, that intake process goes, once we do a phone consultation, get all the facts, figure out whether or not we can do anything, we set an appointment.
Okay.
And we go through, we want to look at what the consumer was served with, what's attached.
Right.
We want to start looking at dates. We want to start looking at assignments. We research all the people in the chain of title, as well as the debt buyer and the debt collection law firm for recent lawsuits that have been filed against those entities for violations of some other laws that would put our potential client not only on defense but on offense. And, you know, one of the things that we do is we talk about what it's going to cost to hire us to defend.
Okay.
Some people are very surprised at how affordable we make it for them to hire us.
But the key is that you can actually tell them up front, here's what it's going to cost you. And
right.
Then they can make the decision, is this worthwhile for me?
Right. We don't have, this is not, when we do debt defense, first of all, we talk about what it's going to entail. We take a look at everything from where is the courthouse, who is the judge, and that all factors into how we charge. We accept payments. We usually do debt defense 99% of the time on a flat fee basis.
Right.
So we take into account all sorts of factors. In fact, there were a couple of courts for a while where one judge courthouses, and I'm not going to mention any names, but we had, I mean, just because of the amount of aggravation and extra work that those judges caused us and other attorneys, we had, we added a little bit onto our normal flat rate. And, we would let the clients know, and hopefully over the years letting the clients know led in some small way to those judges no longer sitting on the bench.
Right. Well, here's the thing. So you have a website.
I do.
What's the URL?
www.clgplc.net.
Okay.
But you can just look up Adam G. Taub and Associates Consumer Law Group.
Yeah, and I'll put the link right across here in a second, and I'll put it in the description of the video below.
You can do that?
Yes, of course I can. Yeah, not only am I the talent, but I'm also the producer.
So if I look down right now, I'll be pretending to look at the link going by on the screen, or
no, it'll be static. It'll be
static.
But if you go like this, just like this, I bet I can frame it right between your hands.
Okay, ready?
There we go.
I'm gonna go like that.
There you go. Exactly.
Thank you.
There you go.
That was great. Oh wow.
That's also a touchdown in
great.
Australian rules football. They go like this. But another story.
Okay.
So the key is, and we're going to wrap it up now because I have no idea how long we've been talking. Because
probably longer than you wanted to.
Probably longer, but I can edit out all the articles and adjectives. It'll be a little while, but it'll be much shorter.
Pronouns are on the way out too.
The kids aren't using them anymore.
That's right.
But the upshot is this: if you get sued because someone says you owe money, whether it's a credit card, whether it's a car loan, whether you don't even know what it is, somebody says you owe them money, and you're in the state of Michigan, because you're licensed like I am in the state of Michigan, someone could go to your website, get your information, call the office, and speak to somebody here at no charge.
That's correct.
And you can then, after asking some very, very basic questions about what's in the lawsuit itself, you can say, here's what it would cost you to defend, here's what I think I can probably do for you, and then they can make the informed decision about whether or not it's economically reasonable for them to do so.
Right, absolutely.
Okay. I think I summed it all up right there.
I think you did.
So
thank you.
Thank you for coming on my show and in your office.
Thank you.
And we will wrap that up. That's Adam G. Taub.
Yeah,
Right?
Adam G. Taub.
Adam G. Taub. And I'll put all the information below because that URL is confusing to me. As always, thanks for watching. Questions, comments, put them below. Talk to you later. Bye-bye.